Thank you to my colleague and friend, Madison Lesgard, as well as the panelists who have spoke this morning. It was an enlightening and enriching conversation. My name is Ambria Smith, and I will be the moderator for the second half of this morning's conversation. We're going to switch gears, and we're going to talk about the Pennsylvania Constitution. Under the Pennsylvania Constitution is Article 1, Section 27, and it's known as the Environmental Rights Amendment, abbreviated as the ERA. Today's topic will discuss what exactly does the ERA mean? Who does it apply to? Does it apply to everyone, including EJ communities? And we will learn what EJ actually means. And if so, if it does apply to EJ communities, can such communities use the ERA to keep their neighborhoods safe? So to start off this conversation, we will first hear from Meg Murphy. Now, I just want to let everyone know that everyone's biographies are posted on the Villanova Law Symposium's website, but I just want to tell you a little bit about Ms. Murphy now. Ms. Murphy is a senior attorney in the Office of Chief Counsel for the Pennsylvania Department of Environmental Protection. She is the agency's lead on issues related to the Environmental Rights Amendment. So she will lay the foundation in her presentation of the ERA and how the state government treats the ERA. Let's give it up for Ms. Murphy.
All right, so this is going to be a condensed version of what is the Environmental Rights Amendment. And I just wanted to reference David's talk at the beginning of the last session and how he talked about we are in unprecedented times and that there is a lot of chaos coming from DC. But an important sort of pivot is that doesn't change Pennsylvania's laws and it doesn't change Pennsylvania's Constitution. And it's, I think, really useful to know that Pennsylvania has a very well-developed web of state environmental laws that are independent of the federal laws. And we're charged with enforcing those laws and regulating activities that impact the environment, and in some cases in areas that are not covered by federal laws. So with that, I'm going to start. What I'm going to try to talk about in 20 minutes is the history and the context of the amendment, which I think is an important place to start. And I'm going to do this, I'm sorry, you know, glasses. And then I'm going to talk about the first 40 years after the amendment was passed. What did we see in terms of environmental law development? And then I'm going to talk about there was a really significant sea change in 2013 based on a Supreme Court decision, kind of changed the landscape. I'm going to talk about that a little bit. And then I want to talk about practical implementation. All right, so first the historical context. All right, iconic picture of Washington crossing the Delaware depicting the Revolutionary War, December 1776. That's what this iconic painting portrays. Pennsylvania's Constitution had been adopted 2 months earlier, in September 1776. 2 months before that was the Declaration of Independence. So the context of Pennsylvania's Constitution was that we were at war. We were declaring that we were going to govern ourselves separately from England. Our Constitution, Pennsylvania's Constitution, the primary drafter was Benjamin Franklin. Pennsylvania's Constitution served as the model for the United States Constitution, which was drafted 1788 or adopted 1788. I may be getting that wrong. I'm nervous, history major. But what Pennsylvania's Constitution did was it radically, quote unquote, for the time, embodied the concept of self-governance, democratic self-governance. And an important feature of the first Constitution of Pennsylvania, there were subsequent constitutional conventions that established the current frame of government as we know it. But in the 1776 Constitution, the very first article, so the different articles in the Constitution establish the various institutions that we've chosen to govern ourselves, the judiciary, legislature, and the executive, right? Pennsylvania, executive's governor, legislature we know, judiciary we know. The first article of Pennsylvania's Constitution are the people's rights. That's a really significant structural choice by Pennsylvanians when we developed our first Constitution. So as Ambria mentioned, what we're going to talk about is Article 1, right? So that's one of the provisions in this first section of our Constitution. Again, the people's rights. Sorry, I'm trying to go fast. Oh, I didn't start my timer. All right, I've got to keep myself on time here. All right, so Article 1, Pennsylvania's Constitution, striking structural choice. The very first provision in Pennsylvania's Constitution is this concept of inherent rights, right? So the people of Pennsylvania have inherent, inalienable rights, and that's the first part of our Constitution and the first section of our Constitution. Okay, so that's the mini historical context. Why then, in 1971, did we amend our Constitution to specifically add another provision to Article 1? Why did we do that? What's the context again? And this was referenced in the previous section. There was, an environmental awakening, an environmental revolution that was driven by the burning rivers, right? That Professor Ullman referenced. That's the Cuyahoga River. I grew up in Ohio. Cuyahoga River caught on fire 11 times, right? This picture that made the national news in the 1960s was the 11th time, right? This was on the cover of Time magazine, the picture on the right. Gigantic oil spills, Santa Barbara, nuclear testing. Scientists were concerned, right? So there was this environmental awakening in the 1940s, 50s, and 60s. Rachel Carson's book, Silent Spring, was published in 1962. She was one of the concerned scientists concerned about the persistent radioactivity from the nuclear testing. She was also concerned about chemicals in the environment and what they do to ecosystems and to public health, right? So at the national level, the public's attention was captured related to the environmental impacts and consequences of human activity, things like developing new chemicals and putting them in the environment, nuclear testing. In Pennsylvania, we also had the environmental revolution, and our sort of awareness was informed by a long legacy of resource development, resource extraction. So we had the trifecta: timber harvesting, coal mining, and oil and gas development. Oil and gas was discovered in Pennsylvania, right? So we have a long history of environmental resource extraction that was unregulated, right? So what we see in Pennsylvania by the 1900s was Penn's woods were nearly completely clear-cut, right? By 1900, Pennsylvania was nearly clear-cut. These are photographs from the DCNR. These depict kind of denuded hillsides, mountains in Pennsylvania, which are now reforested, good news, reforested, all right? But there are consequences associated with the timber harvesting that were significant in terms of not just the trees, but waters, loss of game. So this is what unregulated oil and gas development looked like in 1865. This is a photograph from Pioneer Run in western Pennsylvania. This is what unregulated oil and gas development looked like then. Mining, there are environmental consequences associated with coal mining. Calm banks, I had never seen calm banks before until I started to work with the Department of Environmental Resources in 1992, and I drove up to Wilkes-Barre, and I'm like, what is that? Somebody tell me what that is. I'd never seen anything like that before. That's the top picture. Mountains of coal refuse, right? Never seen anything like it. Pennsylvania, we have a lot of streams that were damaged by acid mine runoff from the discharges from the mines. Mine refuse impoundments would fail, resulting in what we see on the bottom left. And we still have underground coal mines that are on fire today, right? So significant legacy from resource extraction. There were also some environmental disasters in Pennsylvania that were really significant, made the national news, but impacted Pennsylvanians. There was the 1948 Denora smog inversion that killed I think 20 fatalities, and 14,000 people had respiratory problems. This was kind of like that London fog inversion that was much more catastrophic. This was from air emissions from US Steel. The Glen Alden mine discharge disaster in 1961 made Sports Illustrated because it killed 300,000 fish. This galvanized the sportsmen to be the initial environmental advocates in Pennsylvania. So significant environmental catastrophes in Pennsylvania. Another one is the Centralia mine fire, right? So underground mine fire started in 1962. It continues to burn today. The whole town had to be relocated. The whole town, look it up, Centralia mine fire. It's kind of near Knoebels, if anybody's ever been to Knoebels. Mine fires continue today. Again, when I started in Wilkes-Barre, I joke and say they called my bluff and sent me to Wilkes-Barre because I really wanted to work for DER. Every day when I would drive into work, if I would take the back road, the forest would kind of be smoking like this. And I thought, oh, the fog, the mist, how romantic. No, it was mine fires, right? So they persist today. All right, so that's the context of Article 1, Section 27. How did it come about? Well, a young lawyer, and it really revolves around the history of Article 1, Section 27, it centers on, and John Dernbach could speak to this, Franklin Curry, a young lawyer just out of law school, right? So probably close to a lot of your ages, who knew Bassie Beck, the guy whose picture was in the Sports Illustrated article. Bassie Beck, the sportsmen were galvanized to try to get the legislature to protect Pennsylvania's resources, asked young Franklin Curry to draft amendments to Pennsylvania's water pollution law, which was a precursor to the Clean Water Act. We've had a clean water, clean streams law on the books in Pennsylvania since 1937, right? But a lot of people were exempt from having to comply with this law. Bassie Beck wanted mining to be subject to the Clean Streams Law. He asked young Franklin Curry to draft amendments and then to present them to the legislature. He did that. They were adopted. Franklin Curry then ran to be a representative in the Pennsylvania state legislature on a platform of clean water, and he was elected. All right, so kind of the wave was rising in Pennsylvania for environmental protection. Franklin Curry came into office with this rising tide, and that legislature that he was a part of from 1965 to 1972 passed more environmental laws than had ever been on the books in Pennsylvania. A really significant level of state oversight of activities that cause pollution. These are some of the laws that legislature passed. So this is a really significant part of the history of Article 1, Section 27, right? Article 1, Section 27 came after this really significant effort by these legislators to update and to address how do we protect ourselves from pollution but continue to prosper as a state. So they developed a number of laws. I'm not going to go through all these. That was a campaign picture that Franklin Curry ran on and won. This was water, the clean water was his platform. But Franklin Curry recognized wisely that the tide turns, right? Tide always turns, pendulum swings. That's just the nature of history. And what he recognized was, once people experience environmental regulation, people are going to want to undo that, right? That's how we are. That's human nature. And so the epiphany he had, and I remember, John, when I heard Franklin Curry say this, he was drinking his coffee and reading the New York Times, and he read that New York was contemplating a constitutional amendment to enshrine environmental protection. And the light bulb went off, and he thought, you know what, that's what we need. We've just done all this great work. People are going to want to undo it. It won't be that hard to undo. Let's protect what we've done in the Constitution. And Franklin Curry drafted the amendment that then became Article 1, Section 27. So Pennsylvania's amendment was adopted through the process that you go through to amend the Constitution, which I don't want to get into in a lot of detail. But I want to reference something again that David Ullman said, in the earlier panel. What is really striking about the passage of Article 1, Section 27? You have to, each of the House and the Senate in 2 consecutive years has to vote to approve a bill before it goes to the people to vote on. The first time around, unanimous in the Senate, unanimous in the House of Representatives. Second time around, unanimous. Can you even imagine? 1969, there had been assassinations. There was the Vietnam War. We were a divided country, not unlike now. Unanimous, right? The voters ratified Article 1, Section 27 by a margin of 4-1. It's extraordinary. The Equal Rights Amendment was on Pennsylvania's ballot the same year, Article 1, Section 28. That passed by a margin of 2-1. Passed, right? But there was double the support for the Environmental Rights Amendment. So that's, I think, a really significant thing to just bear in mind related to the history here. Okay, so here's the amendment, finally. I'm 10 minutes in and we're looking at the amendment. All right, there's 3 sentences. Okay, the first sentence is a kind of traditional people's rights. The people have the right to clean air and pure water, and then the rest of the sentence. The second and the third sentences are really interesting and unique in terms of sort of a rights provision in a constitution, in that they create a public trust. The people of Pennsylvania own the public natural resources in common. And the government of Pennsylvania is the trustee, right? So this is a really interesting and unique structure to Pennsylvania's constitutional amendment. There's no federal counterpart. It's self-executing. That means what you didn't see in that text was, and the legislature will decide when you have to do this, right? You don't see that in Pennsylvania's provision. It's reactive. It's looking back at that historic legacy, pollution, contamination, and it's looking forward. How can we prevent future degradation? There are individual rights, and there's a public trust, and it's really not like any other state's constitutional provision. I can never remember which state. There's one other state that has provisions somewhat similar to Pennsylvania's. Montana has a strong constitutional provision like this, but really Pennsylvania's constitutional environmental rights amendment is probably the strongest constitutional provision in the country. I don't think I'm overstating that. I'm looking at John. He's not, okay. So what happened after the Environmental Rights Amendment was passed? Well, a lot of stuff happened at the legislative level. What you see, and I'm not going to talk about each of these laws, but what you see from 1971, through the 90s, is there are additional laws passed by the Pennsylvania legislature, some of them really significant pillars of our environmental regulatory structure in Pennsylvania, that now reference in the purpose section, one of their purposes is to meet the objectives of Article 1, Section 27. So there are a lot of laws that do that. I'm not going to talk about each one. These are in the materials, but this is a really long list, right? What has happened since that time as well is we've seen a lot of improvement, right? So we saw the burning rivers, we saw the oil spills, we saw the clear-cut hillsides. What has happened since the environmental awakening and since this awareness of the need to moderate human activity to protect the environment and to protect public health is we've cleaned up a lot, right? But we've still prospered. So there's been that balancing. How do we do what we do? How do we be prosperous in a way that also keeps us healthy and keeps our environment healthy to keep us healthy, right? So these are the accomplishments. Again, I'm not going to go through these in detail, but significantly, I remember driving from Ohio to Pennsylvania and seeing all the dead trees along the turnpike, right, from acid rain, right? You don't see that so much anymore. There's been a lot of recovery. So this is kind of the hopeful part of what I observe related to environmental protection, which is, we've solved a lot of problems. We've cleaned up a lot of contamination, and laws have been the driver for that activity. All right, okay, so there was a lot of development on the legislative front. Cautionary tale. This is something I wanted to focus on sort of before we get our panelists up here. What happened in the courts after Article 1, Section 27 is a different story. There were two significant cases that happened right out of the gate. The consequence of those adverse decisions was that when I was a young lawyer, starting right out of law school at DER, although the amendment was on the pictures in everybody's offices and it was on our business cards, we didn't talk about it. And when I, as a young lawyer, asked my bureau director, so how do we ensure we're complying with Article 1, Section 27? The answer was, oh, we're good to go. If DEP and the regulated community comply with the statute and regs, you don't have to do anything else. We're good to go. You don't have to look at it or think about it. So what that meant was for the first 40 years of the amendment's existence, not of my practice, I'm not that old yet, but for the first 40 years of the amendment's existence in the courts, it was not a tool that was used either offensively or defensively. It just was not a factor because of these cases. I think John's going to talk a little bit more about that, so I won't go into a lot of detail. The very first case was an offensive case brought by the governor and the attorney general against a private party who didn't have to get any permits from the environmental agencies and who had worked out their plan to build a viewing tower with the National Park Service. And the governor and the attorney general said that offends rights that are protected, rights to, the first sentence of the amendment, aesthetic views, historic. The courts didn't agree. The second really significant case that kind of led to what was implemented in effect as you're good to go was a PennDOT permit. And a big part of what is not told about this case, Payne v. Kassab, is that PennDOT undertook their project under one of those laws passed by Franklin Curry and his legislature that had a really robust environmental review built into their development process, right? So that's, I think, was the effect of this case. Okay, paradigm shift. I think John is going to talk about this too. I don't want to get into too much detail. What is significant, though, is that in 2013, Robinson Township in Washington County and some individual appellants as well sued the legislature for amendments to the 2012 to the Oil and Gas Act. Those amendments, and I think John's going to talk about this more, went too far. They eliminated a municipality's ability to say anything about oil and gas development. And they created some other standards that really hindered the executive's exercise of expertise related to some of the environmental decisions. What's interesting about this 2013 decision is that the majority of the court agreed that these provisions were unconstitutional, but they didn't agree on the basis of the unconstitutionality. So the really significant decision that changed everything, the Robinson Township decision, is actually a plurality decision written by Chief Justice Castile. But it is the first time the Supreme Court really examined Article 1, Section 27. And if you don't read any other opinion, you should read Robinson Township and Chief Justice Castile's plurality opinion, because it provides the history of the amendment, the purpose of the amendment, the history, the legacy of environmental degradation, and what the drafters intended when they drafted the amendment. But a plurality, right? So what happened then that is significant, that cemented the plurality. We might not be talking about the plurality opinion so much if there hadn't been the follow-on case in 2017 also challenging the legislature. Isn't that interesting, right? You think about it. The impetus for passing the amendment came from the legislature in 1969, 1970, because they wanted to protect all that work they'd done. What leads to us now talking about Article 1, Section 27 was a legislative overreach related to the oil and gas industry. So the 2017 case was, I'm not going to get into the weeds, but it was about use of monies collected associated with leases of public lands for oil and gas development. And the decision by the General Assembly to just take all that money and use it for other stuff, not for environmental protection. The Supreme Court said, no, that's not consistent with the public trust obligations in our Constitution. That money has to be put back towards protecting the corpus of the trust. So in the 2017 decision, we see a real emphasis on trust law. So a big part of environmental practitioners' obligation in this arena now is to understand trust law, right? Because these Supreme Court cases now have indicated private trust law applies to evaluate whether or not the Commonwealth trustee is meeting its duties. And John, I think, is going to talk more about this. The duties of prudence, loyalty, and impartiality. And those are important, particularly in the environmental justice context. Okay, so that's something we're going to talk about. So there's been a significant paradigm shift, and I'm over my time. So in 12 years, we've had DEP. I'm just going to go through these pretty quickly. So one thing I want to say, especially again in light of kind of what's going on at the federal level, the state, we're actually, we're kind of on the front lines. I was in court examining witnesses 3 months after I started with DER, right? I was a lot of your ages with no experience before DER. I was in court examining witnesses, right? So we have a lot of experience now. We have 50 active cases probably right now where there are Article 1, Section 27 objections that are live in the case. So we've gotten about 50 decisions from the Pennsylvania Environmental Hearing Board. There is a robust world of environmental case law and precedent that I had never heard about when I was in law school, that's created by the Administrative Tribunal in Pennsylvania and then the Pennsylvania State Courts, the Environmental Hearing Board. They have, their docket is online. You can search the cases, you can see what they're all about. But DEP issues permits for waste, oil and gas, air, water discharges, cleanups, underground storage tanks. We get sued by everybody about everything we do. So we're in litigation a lot, right? People don't like what we do. Nobody likes what we do. Industry doesn't like it. Citizens don't like it. So we get sued a lot, right? You get thick skin. So lots of information in the materials, which I think Ambria has put online, about kind of what we've learned. What are the takeaways? Because the Environmental Hearing Board is now the front line of developing the Article 1, Section 27 precedent that we didn't get in the first 40 years, right? So we're kind of still, we don't know what the law is necessarily before the courts because it's still evolving. And we've lost cases where we learn, okay, we gotta do that loyalty and impartiality a little bit differently, right? What I wanted to end with is sort of a precursor to the environmental justice discussion, is a really important part of understanding what the state environmental agency does, is first understanding all the permits we issue. But a big part of engagement with communities then relates to what's the process for getting an approval to pollute, which is what DEP does. We give, and people don't like it when I say this, my colleagues don't like it when I say this, but we give permits to let people do things that impact the environment. Now there's reasonable impacts, right? We have to have energy, We have to be able to dispose of, we generate a lot of waste. We have to be able to dispose of it, right? We need oil and gas. We need the energy from coal mines, solar, wind, all of that is regulated in the development of that. So what does DEP does? Understanding what DEP does is really important. And it's important because most of what the agency does is subject to public comment, public participation, which is a really important tool and a really important leverage when you want to, get mitigation and other accommodations of community concerns, right? So these are all the things DEP does, and we do civil enforcement. We're unlike other states. Other states, they give it to the Attorney General. In Pennsylvania, DEP, so anybody who wants to litigate, DEP does the civil enforcement. So we do enforcement as well as defending actions. So what do the agencies do? What approvals are needed for a project? What are the requirements related to those projects? We have more than 100 chapters of environmental regulations, some of which are this thick, and that maybe is just one chapter, and maybe 3 chapters apply to a project. It's very complex technical evaluation that we undertake. And then what can you ask for as part of that public process? Maybe the applicant qualifies, maybe the applicant has demonstrated they meet all the technical requirements, right? They've got the right setbacks, they've got the right thickness of the liner, they're gonna emit in accordance with limitations, where they've got all the right equipment. But it's still gonna have an impact to the community. What can you ask for? There are a lot of things that you can ask for, and that's in the materials as well. All right, so I want a quick, not questions right now, so I'll switch to, who's next? Okay, all right. So that was the, the condensed version.